Okay, we are streaming live on YouTube now. Ravi sir, please share
No,
the.
ma'am, wait a minute, wait a minute. Just
Yes,
checking.
okay, okay.
Now we
Okay,
are live,
we
sir.
are.
So shall I start?
No, sir, just a minute. I'll share the link with the participants, and then when I give you a go ahead, then you
You
can
said
start, sir.
that there will be some introduction or something like
Yes, sir,
that.
I'll do that. That is what I'm waiting, sir.
Which is just to-
Okay. So, a very good morning and a bright morning to our respected resource person for today, Mr. Jayachanda, and our lovely participants. Welcome to day 6 of this 1 week online workshop on skill enhancement and capacity building for both teaching and non teaching staff. So today we have with us Mr. Jay Chanda, who is working as a joint registrar academics and first appellate authority in University of Delhi. So before I invite him for his session on RTI, I would take this pleasure to introduce him first. So Mr. Jayachanda is working as a joint registrar and a first appellate authority under University of Delhi. He has previously acted as CPIO and first appellate authority of the University of Delhi for almost 8.5 years and has been instrumental in systematizing implementation of the Right to Information Act in the University of Delhi through a single window mechanism. He has dealt with more than 20,000 matters under the RTI Act. He has also delivered several lectures on RTI and good governance before the administrators and faculty members of the university and other institutions. Mr. Chanda has previously worked in various capacities in administration in different central academic, research, and cultural organizations, besides experience of working in various capacities in the University of Delhi, with a total experience of more than 2 decades in academic administrations. Teaching Learning Center, Ramanujan College, graciously welcome you, sir, and we are hope that we continue this association with you in the future as well. We welcome you, sir, and now I request you, sir, to begin your session on RTI. Over to you, sir.
Dear participants, wish you all a very good morning and a wonderful day ahead. Today, I find it very good to be amongst you discussing about the Right to Information Act, with special reference to its implementation, as I understand. Now, when we talk about the right to information, it is a cherished right, a fundamental right as enshrined under Article 19(1)(a of the Constitution of India. It gives us the power to obtain information from the government and its instrumentalities. Governance in academic institutions is required to be viewed from a perspective where we need to look at the administration as well as the academic aspect of the administration. The academic aspect is important because it is the academic institution where the teaching, learning, research, and other such academic activities are carried out. So we need to be careful while dealing with the administration as well as in dissemination of information in an academic institution. We deal with the students, we deal with the teaching faculties, and we deal with the public at large. So the academic institutions are supposed to be people friendly and should be able to disclose maximum information that is possible within the available framework with the public at large. When we talk about the Right to Information Act, here I am giving you a small presentation in the form of a PowerPoint, which is just indicative in nature and mostly taken from the Right to Information Act and few other reliable sources. And you can look at this, and at the same time, we will be discussing it to the best of my understanding. Now, when we talk about the Right to Information Act, it envisages access to information as a right for the citizens in order to promote transparency and accountability, leading to good governance, which is free from corruption and accountable to the governed. Now, we need to understand that when we talk about this aspect, we need to look at the preamble of the Right to Information Act, which is very important here. Now, what happens? This Right to Information Act preamble says that it is an act to provide for setting out the practical regime of right to information for citizens to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of every public authority, the constitution of a Central Information and State Information, Central Information Commission and State Information Commissions, and for matters connected therewith or incidental thereto. And it talks about that the democracy requires an informed citizenry and transparency of information which are vital to its functioning and also to contain corruption, to hold the governments and their instrumentalities accountable to the governed. So basically, it talks about the administration of the information regime in a manner that maximum information is put in the public domain and it is accessible to the public easily. The democratic setup of India envisions constructive participation of the citizens in the process of governance of the country. And as I have already said, the Article 19(1)(a) of the Constitution of India mentions freedom of speech and expression as a fundamental right. Rta Act 2005 emanates from this fundamental right of freedom of speech and expression as envisaged in the Constitution of India. And as we all know, the Freedom of Information Act 2002 is the primer of the Rta Act. Now, the basic premise of the Rta Act, when we discuss, it envisages access to information as a right for the citizens in order to promote transparency and accountability, leading to good governance, which is free from corruption and accountable to the government. An act also envisages a likely situation of conflict in revelation of information with other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. So this particular aspect is very important to understand, that the Act itself envisages that there will be conflict in revelation of information and what to reveal and what not to reveal. Here, it is important to understand that in spite of all these aspects, we need to understand that on this backdrop, the Act envisages it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. I repeat, the paramountcy of the democratic ideal. So this is most important. So information has to be provided. That is the fundamental understanding of this law. Therefore, the Act envisages that it is expedient to provide for furnishing certain information to the citizens who desire to have it. The word mentioned in the preamble is certain information. It doesn't mention about all information, if you can look at the document. Now, when we talk about right to information, what is information we are talking about? Now, the Act says the Section 2F, the Section 2 subclause F of the Rta Act 2005 has defined what is information. And it says the information means any material in any form, including records, documents, memos, emails, opinions, advices, and so on and so forth. You can see right on the screen. It has so many facets, and they are all defined as information. But the two important things which has come for discussion at several fora, including the courts, is the expressions, opinions, and advices. Now, there's a school of thought which thinks that these opinions and advices means that a public authority is supposed to provide or extend opinions and advices under the Rta Act to the citizens. And whenever a request is made for an information intertwined with the opinions and advices, the public authority is supposed to extend that. But in actuality, this does not mean this. This opinion and advices is something which can be extended. The word opinion is extended, and the advice, it is envisaged that it is when such matter is available in writing in the official records of a public authority, and that record can be disclosed if it is otherwise disclosable under the Act. So here under the Act means under the Rta Act. So it is a recorded opinion or advice. If that can be disclosed, so that forms part of information, but not deducing some opinion or advice on the basis of some recorded documents. And one can also see the Right to Information Act, Section 2F, does not mention about explanations or justifications in the definition of information. Now, the next thing is that talk about information, now talk about records. What is record? Records include any document, manuscript, and file, any microfilm, microfiche, or facsimile copy of a document, any reproduction of image or images embodied in such microfilm, or any other material produced by a computer or any other device. Section 2I of the Rta Act actually defines what is a record. It's quite an all-pervasive domain, what has been defined as record. And what is a file? Often we talk about disclosure of information and disclosure of file notings as part of disclosure under RTI. A file means a collection of papers on a specific subject matter assigned a file number and consisting of one or more of the following parts. It is a correspondence and the notes, an appendix to the correspondence and the appendix to the notes. Therefore, information which are contained in a file, including the note portion, comes under the definition of information under this Rta Act. So the question of disclosure of note sheet is very clear that it has to be provided if it can otherwise be provided under the provisions of this Act. Now we talk about public authority. Why the public authority? Because the public authority which is obliged to provide information to the citizens of this country under the Rta Act. Now, the public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by the state legislature, by notification issued or order made by the appropriate government, and includes any body owned, controlled, or substantially financed non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government as per Section 2H of the Rta Act. This is defined. Now, here an important issue comes that substantially owned and substantially financed, even the NGOs are mentioned here. There are several case laws and there are cases where this issue has come for discussion at the highest courts of the highest court of this country and various other courts. And it has been very clearly defined that every institution which receives any kind of grant or any small assistance, they cannot be defined as substantially financed. And there is a Kerala state case, where it has been held that substantially financed cannot be including everything under the ambit that any assistance which an institution gets or an NGO gets. Substantially means it should be really substantial, and it should be shown to be substantial that it comes under the ambit of public authority. Now, what is right to information then? We talk about Right to Information Act. The right to information means the right to information accessible under this act, which is held by or under the control of any public authority. It includes a right to inspection of records, documents, as well as work, taking notes, extracts, or certified copies of documents, certified samples of material, diskettes, floppies, tapes, recordings, anything which can be otherwise disclosed. And Section 2J of the Rta Act defines that particular aspect. Now, under this Rta Act, who can seek information? Now, all the citizens of the country, as per Section 3 of the Rta Act, can seek information from a public authority. Now, the public authorities, NGOs, and various other institutions are not treated as citizens as per the Section 3 of the Rta Act. So when the CPI of an institution receives a request for information under as per Section 6(1) of this Rta Act, and it is from an NGO, or from an institution, from a public limited company, or any other organization, that cannot be treated as within the definition of citizen within the ambit of the Rta Act. It has to be the citizens of this country who are able to seek information under this Rta Act. Now, the very basic process by which an information can be sought from a public authority under this Rta Act. Now, we need to understand that when information is being sought, there has to be a window, a common window for seeking the information. And here it is the CPIO or the SPIO. An application can be addressed or to the CAPIO and CSAPIO, which means it is a Central Public Information Officer or the State Public Information Officer or the Central Assistant Public Information Officer or the State Assistant Public Information Officer, before whom you can request for information from that particular public authority. And the prescribed fee has to be paid as per the mode of payment which is prescribed, and just mere submission of an ill-addressed IPO or sending cash by post cannot be construed as submission of fee as per rules framed under this act. And there are a number of decisions of the CIC in this regard, which clearly brings out that the payment has to be made as per the rules framed under this act. However, applicants who belong to the below poverty line are not required to deposit any fee under this act, provided they have to provide some kind of proof if requested by the PIO or the APIO of the institution. The request of information is required to be specific as per Section 6(1) of this Rta Act. Now, Section 6(1) of this Rta Act mentions the way the information has to be sought by an individual. Before I come to this section, I'd say that this particular section is very important, and because here a lot of important things are mentioned, and it says that a person who desires to obtain any information uh, under this act shall make a request in writing or through electronic means in English or Hindi or in the official language of the area in which the application is being made, accompanying such fee as may be prescribed to the CPIO or the SPIO, and specifying the particulars of the information sought by him or her. So the information request has to be specific. It cannot be all information. The information seeker is supposed to provide a specific account of what information the person is requesting from that public authority. And there is a proviso to that which says that where such request cannot be made in writing, the CPIO or the SPIO, as the case may be, shall render all reasonable assistance to the person making the request orally to reduce the same in writing. There may be a physically challenged person who may come to your office and seek information. So it is the responsibility of the CPIO or the SPIO to actually help that person in reducing his words into writing, and then take the request as an RTA application and do the needful accordingly. And an important factor is that an applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. That means that no locus standi has to be established for seeking an information under the RTI Act. Why that person is requiring this information, what he will do with that information. These are not required to be explained or mentioned in an RTA application. The applicant may seek any information and it can be provided to him if it can be provided within the provisions of this law. And the time frame is that the information to be provided within 30 days in normal cases, within 48 hours where information sought for concerns the life or liberty of a person. There's a proviso to section 7.1 to this effect, and 35 days where the request is received through the concerned APIO, that is the Assistant Public Information Officer, and 40 days where third-party information is involved, and 45 days for information relating to human rights violation from listed security or intelligence agencies. So these are the rough time frame for this. But as regards the information sought under the clause of proviso to section 7.1, the time frame is 48 hours. We'll come to this issue when we discuss the section. An applicant making a request for information shall not be required to give any reason, that I have already mentioned, and it is coming in this slide. You can see that. And this is as per where an application is made to a public authority, and where the public authority feels that this information is not held by that public authority, but it belongs to some other public authority and closely connected to the functions of another public authority, the CPIO or the SPIO, so-called the PIO, I must say, should transfer this application to the concerned public authority as per section 6 subclause 3 of the RTA Act. Now, section 6 subclause 3 of this RTA Act is important to this extent that the PIO is not supposed to sit with that information since it does not belong to that particular public authority and not do anything on that. There may be occasions when you receive an RTA application, and that a particular RTA application has many parts, and in some part of the information is available with the public authority where the RTA application has been lodged, and then maybe part of the information belonging to other public authority. So the CPIO or the SPIO are supposed to forward that application, transfer that application in specific terms to the other public authority, which are closely connected with the functions of that information, and within 5 days of receipt of this particular application. So this is important because then the total information the applicant can get from multiple sources, but still it can be accessed. And when we talk about 30 days, is it really 30 days? No, it is not. It says that information is to be, the act is very clear. Information has to be provided to the information seeker or the applicant, as we may say, as expeditiously as possible. Even it can be supplied in 1 day, even supplied in 2 days. in normal course because the information is readily available. And when the information a seeker has sought some information and it is readily available, it should be provided as early as possible, as expeditiously as possible, and not in any case beyond 30 days of the receipt of the request. But there are certain exemptions which we will discuss at a later time. And when a CPI or the SPIO does not provide information requested by the applicant without giving any specific reason for that, it is construed as deemed refusal of the request. And it is viewed very seriously under this law. We will see it at a later stage. There are fees involved, and one may refer to the cost and the fee rules of the Rta Act, which are framed from time to time and amended from time to time, that there are fees involved in seeking information from a public authority for the people who are not belonging to the below poverty line category. So in that case, that particular fee has to be provided. And but if the information is provided beyond the period specified, like 30 days or 35 days or 40 days, whatever I've discussed earlier, that has to be provided free of cost to the applicant. No fee can be charged if it is not within the time limit prescribed under the Act. And when a request for information has been rejected under Section 7(1) of the Rta Act, the CPIO and the SPIO should communicate to the applicant the reasons for such rejection and the period within which an appeal against such rejection will be preferred, along with the particulars of the appellate authority. So, after getting a request under the Rta Act, the CPIO is supposed to collect and collate the information to the extent possible within the available records. And see that whether that information can be disclosed as per various provisions of this Act. And after he has come to the conclusion that this information is to be provided, the information has to be provided which is disclosable. And if some part of the information is not disclosable, the CPI or the SPI is supposed to invoke relevant provisions of the Section 8 or Section 9 or Section 10 and then provide the disclosable information. And while providing such information, the particular reply should contain the particulars of the first appellate authority as well, because in case the applicant is not satisfied with the reply of the CPIO or the decision of the CPIO, the applicant may approach the first appellate authority, who is a senior officer within the organization itself, and who can have a chance to look at the RTA application and do further remedy if admissible as per relevant provisions of this particular Act. Section 7(9) of this Rta Act is important because it says that information shall ordinarily be provided in the form in which it is sought, unless it would disproportionately divert the resources of the public authority or would be detrimental to the safety or preservation of the record in question. Many times, an applicant may seek voluminous information from a public authority on multiple counts, and that information is required to be collected, collated, and then properly indexed and then provided. So obviously, the CPI has to see that the particular information has to be provided. At the same time, it should not disproportionately divert the resources of the public authority in collecting and collating the information. In this context, a judgment of the Honorable Supreme Court of India is important in the Aditya Bandyopadhyay matter, where the disclosure of answer script was dealt by the apex court of the country. And in course of that deliberation, it was very nicely mentioned that the public authority cannot, divert resources beyond a level, in collecting and collating information and providing it to the applicant. So there has to be some balance. So that has to be looked into while looking into this aspect of it. And when it comes to the preservation of the record, the applicant may seek an information about a very old record, and the preservation of that particular document may be in question. So the CPIO has to also see that the safety and the security of that particular document and the condition of the document is appropriate for providing such information under this Act. And there is a DOPT-OM also in this regard, which says that the PIO is not required to deduce anything from a particular material and draw conclusions from that particular material and extend it to the applicant in course of deliberation under this law. So the PIO will provide information which is available in the public record and which can be disclosed under the RTA Act. Now, who is a CPIO or the SPIO? He's an officer designated by the public authority as per Section 5(1) of the RTA Act and is entrusted with the responsibility of supplying information pertaining to the public authority, which can be disclosed under the Act. So basically, the first line of the contact of the citizen with the public authority under this RTA Act is the CPIO or the SPIO. And in organizations where they have appointed, they have designated officers as assistant public information officers, and then the first phase of it is the assistant public information officer. The role of the assistant public information officer many times is misunderstood. Many times people would think that the role of the APIO is actually to assist the CPIO in discharge of his duties. Best of my understanding, that is not the case. The APIO is basically a recipient of a request for information from an applicant, and he only forwards it to the CPIO for further deliberation. But under the provisions of this Act, one would see that additional 5 more days is required when it comes to the limitation for providing information. When a public authority designates APIO, and the APIO obtains that particular request for information and forwards it to the CPIO. But if the public authority has not designated any officer as the APIO, then the benefit of 5 days, or if I say the time frame of 5 days instead of using the word benefit, because there is nothing benefit or loss in this particular law. So additional time frame of 5 days cannot be taken as for providing information. Now, there is a concept of deemed PIO because when a public institution actually engages or designates officers as PIO, there are 2 types of functioning in this aspect, which is very important to understand. There are public authorities who have appointed almost all the heads of various divisions as the PIOs. So that divisional head or the departmental head or the subdivisional head would provide information being the PIO of that particular division, and they will disseminate information pertaining to their division. And what would happen that suppose an RTA application is received with 10 requests spanning over 5 different departments of a particular public authority, and the first person who is receiving that request for information would see how many requests pertaining to his department and then transfer it to his fellow colleagues in other departments. And in that case, those other public information officers with the same public authority are going to provide their information to the applicants separately. Now, the question is that when they do so, this transfer does not mean a transfer under Section 6(3) of this RTA Act. So it cannot be that it takes 5 days, within 5 days it has to be done. It has to be done immediately. And in that case, information is reaching to the applicant from multiple sources if he is seeking information from multiple divisions or branches or departments of a public authority. But when there are public authorities where this mechanism is not there, where the public authority has designated a nodal public information officer as a central public information officer or the state public information officer, as the case may be, who receives applications on behalf of the public authority from the citizens under Section 6(1) of the RTA Act. And then he, after looking at the RTA application, forwards it to various other officers of the institution, and they, in course of time, look at the document and provide information pertaining to their division or their departments, their faculties, and then such information is being collected and collated at a central location, and a consolidated, properly indexed information pairwise pertaining to that RTA application is being provided to the applicant. Personally, I feel that this is the single window mechanism is a rather better mechanism in providing information for the citizens, because they can get information from a single source and they can see what all information that person has requested and what all information the person has received. And similarly, what happens when this particular exercise is being carried out, the CPIO or the SPIO, as the case may seek the assistance of any other officer where he or she considers necessary for proper discharge of his duties. Here, various divisional heads, various section officers, assistant registrar, administrative officers, that information can be sent to various places, and that information is being collected. So all those people, all those officers to whom that information has been requested are supposed to provide information to the CPIO for further transmission to the applicant. And this is as per section 5(4) of the RTA Act. All such officers will be treated as the PIOs under the RTA Act. And any officer whose assistance has been sought under the subsection 4 shall render all assistance to the CPIO or the SPIO and seeking his or her assistance, and for the purposes of any contravention of the provisions of this act, such other officers shall be treated as a CPIO or the SPIO as the case may be. That means, suppose the nodal CPIO has received an RTA application which contains information about 2 departments, and he sends the matter to the concerned departments for obtaining the information. The head of the department of one department has provided complete and correct information, and the other department has either not responded to the RTA application or provided truncated information, or has not given due diligence in providing information to the CPIO or the SPIO. Obviously, being the nodal CPIO, it would not be in his knowledge and understanding that what particular information that has been provided and has not been provided, because that has been held by that particular department. And he forwards that information to the applicant with proper decision. And when the matter comes from hearing at a later stage, and if it is seen that the particular head of the department has willfully not provided any information, or he has destroyed some information, or he has provided part of the information, misleading information, then for all such contravention of this act, that particular head of the department would be treated as a CPIO or the SPIO for the purpose of penal provisions of this particular act. So this is what it is all about the single window mechanism. And in case of disposal of the first appeals, also the similar mechanisms are there in public authorities where they have multiple PIOs, they have multiple first appellate authorities, because the respective senior officer in that particular wing would act as the as the first appellate authority of that wing, and then that matter is being deliberated by that particular officer. But when it comes to the information public authorities, where information is being provided in a central location and through a centralized mechanism, a single window process, there the first appellate authority would need to actually act as a first appellate authority for the entire public authority, as in this University of Delhi. And then that first appellate authority has to decide upon the matter as per the information available on record and based on the decision of the PIO. Now, when we talk about providing information under the RTA Act, there is section 8 of the RTA Act, which mentions about information which are exempt from disclosure under the RTA Act. And the section 8(1) of this RTA Act has provisions from say A to J. So basically, there are 10 exemptions are there, which we will see one by one. And so the 8(1)A of the RTA Act mentions that information, the disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. So such information is not to be disclosed under the Rta Act. The concerned CPIO has to apply his mind and to see whether the information requested falls in this category, and then the CPIO has to invoke this particular clause in saying that this information cannot be provided. So the decision of the CPIO will be based on this particular provision. Similarly, information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court, the CPIO has to take a call on this aspect as well. 81C mentions about disclosure where there's a breach of privilege of the parliament or the state legislature. Similarly, section 81D mentions about information which are held in, including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied that the larger public interest warrants the disclosure of information. That information will also not be provided. Now, there are various court cases in this particular matter, and this particular clause has been well settled now. What information has to be provided and what cannot be provided. Then comes another provision under section 8.1 is the information which is available to a person in his fiduciary relationship unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information as per section 8.1E of the Rta Act. So the 8.1E of the Rta Act talked about the fiduciary relationship vis-a-vis the disclosure of information. Now, what is fiduciary relationship? The word fiduciary has been derived from a Latin word, which means trust, especially with regard to the relationship between a trustee and a beneficiary. The fiduciary relationship includes relationship between the lawyer and the client, the doctor and the patient, trustee beneficiary, bank customer, or something of such nature. The horizon can be expanded, based on various situations, and whatever little is given is basically an illustrative example for the discussion. So this fiduciary relationship issue has also been discussed at length in various judgments of the Apex Court as well as other courts of record from time to time. And it's a well settled principle that what information can be provided and what cannot be provided under this law of fiduciary relationship. The classic example of it can be that disclosure of evaluated answer script. Now, while claiming exemption from disclosure of evaluated answer script, various public authorities had mentioned about section 8.1E as a fiduciary relationship clause, under which information cannot be provided to a student who is seeking a copy of his evaluated answer script. But this matter has been deliberated at length, and it has come to the conclusion that particularly fiduciary relationship is a relationship of trust. And obviously, when a student, an examinee, is taking an examination to test his knowledge and understanding of a particular course of study in an academic institution, that person is depositing that answer script with that particular academic institution for evaluation, and obviously a result emanating out of it, which will be determining that the performance of the student in the particular examination. Now, if the particular result in the examination is, suppose, not as per the expectation of a student, and he wants to see the evaluated answer script to make that person educated about the shortcomings in the answer or anything of that nature, which will enlighten that person so that that person gets the understanding of what went wrong in the process of examination. Maybe somebody has got very high marks in an examination, and that person wants a copy of the evaluated answer script, maybe as a copy to be kept for his personal records. Now, in that aspect, whether the examining body can say that this information cannot be disclosed to the student because of a fiduciary relationship, I think it's not the correct interpretation. It has already been established in various judgments of the honorable courts, because of the reason that if the information is fiduciary between the student and the examining body, now the student himself or herself is seeking his own copy of evaluated answer script. So that cannot be denied to that person under the aegis of section 8.1E of the Rta Act. the information has to be provided to that particular student. But if an applicant who is a student or maybe a citizen of this country who is not a student of that academic institution or for that any academic institutions is seeking a copy of the evaluated answer script of various students who has appeared in that particular examination, and he wants to see that answers. But that information cannot be provided to that particular individual, because the question of fiduciary relationship will definitely come there, as well as those evaluated answer scripts are treated as personal information of those particular students who have appeared in the examination. And therefore, there is a section 81J of this RTA Act which deals with the personal information. We'll come later to this discussion, where we will see that such information also cannot be provided. Now, information received in confidence from the foreign government in section 81F, then information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. So section 81G talks about the element of physical safety of an individual if information is disclosed under this act about a particular individual. But this is a very important provision, because there are various activities being undertaken by a public authority where assistance is being sought of various individuals in various capacities, where disclosure of their identity may put their physical safety in danger. And there is a case. I think there's a case of Bihar Public Service Commission involving Bihar Public Service Commission, where information was sought about the identity of the members of a selection committee who has selected candidates for a particular examination, but it was not disclosed, as disclosure of their identity would actually compromise with their physical safety, because an individual who is aggrieved may like to have the information of those people and then may harm that person at a later date. So that's why this particular clause is very important, and the CPIO or the SPIO, as the case may be, is required to apply their mind while looking at such requests where individuals' information is being disclosed, which has been, and for discharging of any duty, which has been done with a lot of confidence and with understanding that such information will not be disclosed in the public domain. And there are various decisions of the Honorable Central Information Commission, High Courts, the Supreme Court, Honorable Supreme Court of India, which mentions about this particular clause of this physical safety. And another case of Aditya Bandyopadhyay, where it has been held by the Apex Court that the identity of the examiners, coordinators, scrutinizers, head examiners are exempt from disclosure under Section 81G of this Act. Then there is an exemption of disclosure of information when the investigation is going on, and information which would impede the process of investigations or apprehension or prosecution of offenders. Section 81H of the RTA comes into the play. That means when an inquiry proceeding is underway, and suppose during the process of that inquiry, information is being sought by any individual and even by the person who is an aggrieved person, this information cannot be disclosed under the RTA Act. But if a person who is aggrieved and against whom an inquiry is being instituted, that person can seek information from the public authority through the established channels of obtaining information as part of an inquiry proceeding. Nobody stops that from doing, but a right to information under the RTI, disclosure of such information is not a very appropriate measure. And then comes the cabinet papers, including records of deliberations of the Council of Ministers, Secretariats, and other officers. And provided that decisions of the Council of Ministers, the reasons thereof, and the material on the basis of which decisions were taken shall be made public after decision has been taken and the matter is complete or over. Provided further that those matters which come under the exemption specified in this section shall not be disclosed. So this particular matter is also there, that something which is not disclosable cannot be disclosed otherwise. And information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the CPI or the SPI or the appellate authority, as the case may be, satisfied that the larger public interest justifies the disclosure of such information. Now, disclosure of information which is treated as personal information, it is a really huge area of discussion, and a lot of deliberations have taken place on various matters under the Rta Act. Which information is treated as personal information, which information is not treated as personal information, and a huge responsibility has been cast on the CPI or the SPI or the appellate authority, who would have to see that what information can be disclosed under the Rta Act. But in this case, it is very clear that any information, if the disclosure of which far outweighs the importance that such information is required to be disclosed in the public domain and in the public interest, so that the CPI or the SPI or the appellate authority can take a call on that. And notwithstanding anything in the Official Secrets Act 1923, nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs a harm to be protected, to the protected interest as per section 8.2. So basically, information, if it is there is a larger public interest, so appropriately that has to be dealt. Now, subject to the clauses of A, C, and I of the subsection 1, any information relating to any occurrence, event, or matter which has taken place, occurred, or happened 20 years before the date on which any request is made under section 6 shall be provided to any person making a request under that section, provided that when any question arises as to the date from which the state period of 20 years has to be computed, the decision of the central government shall be final. Obviously, there are appeal procedures involved in it. As far as personal information is concerned, there is an important decision of the Honorable Supreme Court of India in G.R. Deshpande versus CIC matter. And it was held that income tax returns, information about movable and immovable property, etc., are treated as personal information of the employee concerned as per section 81J of the Rta Act. Similarly, there are cases in the apex court where decisions are there where the annual performance appraisal reports, the APRs or the ACRs, the annual confidential reports of the government servants, are not to be made public. They are information treated as personal information of the official concerned, and obviously can be given to that particular individual. In fact, in these days, we all know that the annual performance appraisal reports are otherwise provided to the officer who is being submitting the APAR to the authorities. So basically, this particular APAR is already available to the particular individual whose performance appraisal has been done. But in this case also, it has been mentioned that the CPI or the SPI can consider the disclosure of such information in a given case if the CPI or the SPI is satisfied the larger public interest justifies the disclosure of such information. So the last word still remains with the CPI or the SPIO, whether they want to disclose that information under the Rta Act, looking into the larger public interest. Exemptions under Section 8 of the Rta Act are in consonance with the Article 19(2) of the Constitution of India, which envisages a reasonable restriction on the exercise of freedom of speech and expression, for that matter, any fundamental right which is available to all the citizens of the country under Section 19 or other sections of the fundamental rights. So there are reasonable restrictions, and that is enshrined in Article 19(2) of the Constitution of India, and obviously Section 8 is very akin to that, and that says that which information cannot be disclosed because it has other ramifications. Section 9 of the Rta Act is basically says that without prejudice to the provisions of Section 8, a CPIO may reject a request for information where such a request for providing access would involve an infringement of copyright subsisting in a person other than state. So the issue of copyright has been dealt here, but the copyright is of an individual. It is not of a state. So therefore, the state cannot say that a particular document cannot be disclosed because of a copyright issue. So it is an individual's parlance. So one has to look at this aspect from that perspective. Now comes the issue of the doctrine of severability. It comes to section 10, that what information can be disclosed uh, in part means, suppose the applicant has sought information under the Rta Act where part of the information is non-disclosable as per various provisions of section 8 and 9 of the Rta Act. But a part of the information is disclosable, and that part which is disclosable has a meaning in itself. It is not a meaningless piece of information which can be disclosed. So the CPIO or the SPIO should make a distinction and to see that particular part which is disclosable, meaningful part it should be, and it can be disclosed after severance of that part which cannot be disclosed under the Rta Act. And while doing so, the CPI or the SPIO is supposed to give a reasoned decision and bringing out this aspect and then provide the information which is disclosable to the applicant. And obviously, that disclosure would mean that the disclosable part of the information has been provided to the applicant, and that means in the public domain. An important aspect of this Rta Act also deals with the third-party information. Third party obviously is an individual who has provided information to the public authority, or his information remains with the public authority in course of various processes, which other individual is seeking under the Rta Act. Now, where the CPI or the SPIO intends to disclose any information or record a part thereof, even a part thereof, on a request made under this Act, which relates to or has been supplied by a third party and has been treated as confidential by the third party, the CPIO or the SPIO shall, within 5 days from the receipt of the request, give a written notice to such third party of the request and the fact that the CPIO intends to disclose that information, to make a submission to him from the third party, that the CPIO would say to the third party that he may give a submission to the CPIO regarding whether the information should be disclosed or not. And the CPIO is supposed to take the submissions of the third party into consideration while deciding the matter to provide information or not to provide information. And if the CPIO, after taking into consideration this aspect, decides to provide information, a notice is also to be provided to the third party that it is being done accordingly. And the third party has a right to go for an appeal till that stage of second appeal, first appeal and the second appeal in such matters. And the CPI and the third party is heard at both the forums on this particular aspect, which is highlighted in section 11.2 and section 11.3. So I'm not getting into the detail of it. This is basically a procedural aspect which has to be followed. Then comes the question of first appeal. When the CPIO has either provided information or he has given a reasoned decision of not providing any information under various provisions of this Act, especially section 8 and 9, and given a reasoned decision, or the CPIO has refused to provide any information, or the CPIO has not responded to the Rta application, and any person who does not receive these kind of things, he can prefer a first appeal before the senior officer in the same institution as a designated first appellate, who is a designated first appellate authority, and make a case for him that such information has not been received by that particular individual. And that should be done within a period of 30 days, provided that such officer may admit an appeal after the expiry of the period of 30 days if he or she is satisfied that the appellant was prevented by sufficient cause from filing the appeal on time. So basically, this particular aspect is that even 30 days it is passed, that appeal can be registered. And when an appeal is preferred against an order made by the CPI or the SPIO under section 11 to disclose a third-party information, the appeal by the concerned third party shall be made within 30 days from the date of the order. Obviously, that is very akin to the Section 11 of the Rta Act. Now, after the first appeal is received, the first appeal is being decided by the first appellate authority within a period of 30 days from the date of receipt of the first appeal, and in no case beyond 45 days of the receipt of the first appeal. But in case an extended time is being used, that should be, the reason for that has to be recorded in writing. So this is important. Now, after this first two sections of section 19, I'm coming to an important provision, that is a complaint proceeding, before I discuss the second appeal part of it. Now, complaint proceeding is a separate proceeding and under the Rta Act, which is different from the appeal proceeding. So section 18 provides for the grounds of making a complaint by a complainant who is aggrieved by the various reasons specified under this section before the respective Information Commission for remedial action. And where the respective Information Commission is satisfied that there are reasonable grounds to inquire into the matter, it may initiate an inquiry accordingly. While inquiring into any matter under this section, the respective Information Commission has the same powers as are vested in the civil court. And one would like to understand that various reasons which are being mentioned, that a particular individual has been meted with, that first a complaint can be lodged in the before a respective Information Commission. And the section, the relevant part of it says that is subject to the provisions of this act, it shall be the duty of the Central Information Commission or the State Information Commission, as the case may be, to receive and inquire into a complaint from any person who has been unable to submit a request to the CPIO or the SPIO, and or the CPIO or the SPIO has refused to receive the application, who has refused access to the information, who has not been given a response to a request, who has been required to pay an amount of fee which he or she considers unreasonable amount, and who believes that he or she has been given incomplete, misleading, or false information under the Act. And in respect of any other matter relating to requesting or obtaining records under this Act, a complaint can be lodged directly under the this section to the concerned Information Commission. For the central setup, it is the Central Information Commission. For the states, it is the State Information Commission. And the State Information Commission is on receipt of the complaint, and if it sees that there is a reasonable ground is there to inquire into the matter, it may start an inquiry in the process. So this inquiry proceeding is entirely different from the appeal proceeding. It does not require a first appeal to be filed before a complaint proceeding starts. So after the CPIO stage, the complaint proceeding can start directly before the respective Information Commission. And now, coming back to the second appeal provisions, section 19.3 mentions about the provisions of the second appeal before the respective Information Commission, and it is basically done within a period of 90 days from the decision of the FAA. But the respective commissions may admit an appeal after the expiry of that 90 days also, if it is satisfied that the appellant was prevented by sufficient cause from filing of the appeal time. So even after 3 months, a second appeal can be admitted. And if the decision of the CPIO or the SPIO against which an appeal is preferred relates to information of a third party, the CIC or the SIC shall give a reasonable opportunity of being heard to the third party. So because third party's claim is there, so hearing has to be done, as I've already mentioned earlier. And in any appeal proceeding, the onus to prove that a denial of a request was justified shall be on the CPIO or the SPIO who denied the request. So the onus of not providing an information always lies with the public information officer concerned. He or she has to prove that before the CIC that or the SIC that whatever decision has been taken in highest good faith. There is no malafide involved in that, and he or she has done the just and appropriate duties which are envisaged under this Act. Now, that Section 19.6 says an appeal under subsection 1 or subsection 2 shall be disposed within 30 days and within such extended period not exceeding 45 days. And Section 19.7 mentions about that the decisions of the Information Commission shall be binding. And Section 98 mentions about the uh, powers of the Information Commission in disposing of the appeal proceedings, where they may require the public authority to take any such steps as may be necessary to secure compliance of the provisions of this Act, which includes providing access to information if it was not done earlier, by appointing officers. Suppose some public authority has not appointed a PIO, so the Commission can direct the Information Commission can direct the public authority to appoint a PIO who will be in effect providing information to the information seekers under this Act. Then publishing certain information or categories of information by making necessary changes to its practices in relation to the maintenance, management, and destruction of records. Suppose a public authority has a record retention schedule which is not proper, or it doesn't have any record retention schedule. So any information which is being generated is being destroyed without any reference to any rules per se. So the CIC or the SIC may direct the public authority to prepare a proper record retention schedule and maintain and manage the records accordingly, and only destroy those who has actually been which has actually crossed the time limit or limitation prescribed under the record retention schedule of that particular public authority. By enhancing the provision of training the right to information to its officials, because since this is a law which has to be implemented by the public authority and everybody is not a law graduate or may not be having understanding of this law in detail, so training sessions for that has to be also done by various public authorities, and the Information Commission may direct a public authority to do so. And also by providing it with the annual report of the compliance of the various sections under Section 4, which we'll discuss at a later stage. And there are other obligations in the second other authorities there. Suppose require the public authority to compensate the complainant for any loss or other detriment suffered. So this is a very important provision that if an Rta application has been filed by an applicant and where he has not got appropriate information and it gone to the second appeal stage, and the Information Commission finds that it has caused loss to the particular individual for non-receipt of such information at a particular time. So even a compensation can be given to that particular person from the public authority. So this is a very important clause actually, and this is actually in terms of monetary terms. So basically, so this will also be a detriment that a public authority should provide information on time which can be disclosed, or impose any of the penalties provided under this Act, and also at the same time reject the application because sufficient information or appropriate information has already been provided by the PIO or at the first appeal stage. And the CIC or the SIC shall decide the appeal in accordance with such procedure as may be prescribed, and there are certain rules for that which has already been framed. And the next clause is a very important clause. It is important because there are not many legislations in the world where, not only India, even in the world, where a penalty in terms of fine has to be has to be given by the PIO concerned if certain conditions are met as per this provision. It says that the CIC or the SIC at the time of deciding any complaint or appeal is of the opinion that here the word is complaint or appeal, both, as the case may be, as without any in the opinion of the CIC or the SIC, the case is that information has been denied without any reasonable cause, refused to receive an application for information, or has not furnished information within the time specified under subsection 1 of section 7, or malafidely denied the request or information, or knowingly given incorrect, incomplete, or misleading information, or destroyed information which was subject of the request, or obstructed in any manner in furnishing the information, which shall impose a penalty of 250 rupees each day till application is received or information furnished, and the total amount shall not exceed 25,000 rupees. So this is a very important provision. And section 20, subclause 1, categorically mentions the grounds, the specific grounds which will be looked into by the Information Commission while looking at the conduct of the concerned PIO in dealing with a particular matter under this Act, provided that the CPIO or the SPIO shall be given a reasonable opportunity of being heard before any penalty is imposed on him or her. This is important because the CPIO or the SPIO may have his or her side to explain to the Information Commission and the circumstances or the thoughts, so that the Information Commission is satisfied that there is sufficient ground for imposition of penalty. Just issue of a show cause notice by the Information Commissioner to the PIO does not automatically entail imposition of penalty. The notice is being replied by the concerned PIO, that matter is heard in detail, and then only such a decision is taken and the decision is being conveyed by the respective Information Commissions. But one thing is important: the burden of proving that the CPIO or the SPIO has acted reasonably and diligently lies with the CPIO or the SPIO himself or herself. So that is very important. So, and there is some more issues on penalty, where the CIC or the SIC, as the case may be, at the time of deciding a complaint appeal, is the opinion that that without any reasonable cause and persistently. Now here the word comes when it comes to the disciplinary proceedings. Persistently means it is not a singular mistake or a singular omission. Persistently failed to receive an application for information, or has not furnished information within the time specified under subsection 1 of section 7, or malifiedly denied the request, or knowingly given incorrect, incomplete, or misleading information, or destroyed information which was a subject of the request, or obstructed in any manner furnishing the information, shall recommend for disciplinary action against the concerned PIO under the service rules applicable to the particular person. So basically, here an important issue is that it is not the one complaint or one matter. Maybe it is the persistent, omissions of the officers that may incur the penal provisions under section 20 subsection 2. Now, important is section 21, which says that there's a protection when a work is done by the PIO or the officers under this Act in good faith. So no suit, prosecution, or other legal proceedings shall lie against any person for anything which is done in good faith or intended to be done under this Act or any rule made thereunder. And there's another provision, the Rta Act, to have overriding effect. Now, this particular clause says that the provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act 1923 or any other law for the time being in force, or in any instrument having effect by virtue of any law other than this Act. That means this Act will have a supervening provision by this particular section. But the reading of this non-option clause in section 22 of the Rta Act has to be so interpreted that the preamble and the enabling provisions of the Rta Act will be given meaning only when there is no statutory bar of any kind in providing the information. The rule of construction demands that so long as the provisions exist in the statutes, they have to be given effect to by harmonious construction. Both the statutes will be allowed to have the space without contradicting each other. If there's another statute and the Rta Act, so a harmonious construction has to be done so that a proper justification is there in implementation of the Rta Act. Bar of jurisdiction of courts, that is mentioned under section 23. It says that no court shall entertain any suit, application, or other proceedings in respect of any order made under this Act, and no such order shall be called in question otherwise than by way of an appeal under this Act. That means that suppose an applicant has filed an RTA application and got some information or did not get some information, and the person does not go to the first appeal or the second appeal or the complaint or any other procedures which are mentioned under this particular Act, and goes to tangentially to some other proceeding which is beyond the provisions of this Act, so that kind of proceedings shall not be entertained by any court of law, because the channel of functioning of this law is that the CPIO receives, APIO or the PIO receives the request for information which is being disposed of, and then within a specific time limit, then there's a first appeal, then there's a second appeal or a complaint, And if everything fails, then there are writ jurisdictions of the honorable high courts of the country as well as the apex court. So basically, this is the way the proceedings under this act moves. It is not some other proceeding. Now, when we talk about all these aspects, right now, we discussed till now various provisions of the RTA Act, which relates to providing information when the information has been sought by an applicant and information is provided or not provided, various conditions there too. But we need to understand that there is an entire paradigm in terms of uh, disclosure, which is called the proactive disclosure. Section 4 of the RTA Act basically deals with the proactive disclosure. And in case the public authorities are religiously following the provisions of the Section 4 in letter and spirit, the request for information from the citizens on various routine matters of the day-to-day functioning of the public authority can be reduced to a considerable extent, because many times is information sought by a public authority from a public authority by the citizens is relating to various matters which are otherwise required to be put in the public domain, to various booklets, leaflets, and obviously the website of the public authority, which actually showcases all information which are to be disclosed, which can be disclosed under this act. So Section 4.1 of this RTA Act mandates every public authority to maintain all its records duly catalogued and indexed in a manner and a form which facilitates the right to information under this act and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources computerized and connected to a network all over the country on different systems so that access to such records is facilitated. It means that records in the digital form, an e-platform, right, the website, or the national level coordinations and various levels like the digital libraries and all that, information can be provided in the public domain, which will reduce the request for information from the citizens on various counts. And it also requires every public authority to publish information handbook within 120 days from the enactment of this act. I mean, that time is already over, but I have information that various public authorities have taken much more time than these 120 days. But as and when things have improved over a period of time, people have understood, the public authorities are well educated these days, how the information has to be maintained, properly indexed and cataloged and disseminated in the public domain appropriately. And this information handbook has to have 17 different heads, which includes that is called Section 4.1b, and this is called the manuals under the RTA Act. The 17 manuals has to be actually published, and it is in the form of an information handbook. So the first one is the particulars of its organization, functions, and duties, then the powers and duties of its officers and employees, the procedure followed in the decision-making process, including channels of supervision and accountability, norms set by it for the discharge of its functions, the rules, regulations, instructions, manuals, records, and so on and so forth. The statement of categories of documents that are held. It is a comprehensive, account of everything which is being done by the public authority in discharge of its mandated duties. If one goes through this information handbook chapters, one will find out that almost every information a public authority holds under Section 2J are to be disclosed, barring a few information which are not related to this particular Section 4, disclosure on various exemptions and other functions. So Section 4.1b disclosures are of paramount importance. If a public authority takes it very seriously and discloses every information in the public domain which are otherwise disclosable without waiting for an applicant to seek information under Section 6.1, It would reduce the pressure on the public authority in terms of receipt of applications and its disposal within 30 days or whatever time limit prescribed. So basically, it is the information disclosure suo motu by the public authority, and it helps actually in reducing the number of applications under the RTA Act. It has been seen in various public authorities. And when we say that, suppose a particular head, there is no function of the public authority akin to that, it can be very well mentioned that that particular function is not within the mandate of that public authority. But that does not mean that under the garb of one or two points, some information cannot be provided. The entire information handbook is not being uploaded on the website of the public authority and also published for the information of the public at large. And section 41C talks about publish all relevant facts while formulating important policies or announcing the decisions which affect public at large, and provide reasons for its administrative or quasi-judicial decisions to the affected persons. And section 42 says, it shall be a constant endeavor of every public authority to take steps in accordance with the requirements of the clause B of subsection 1 to provide information suo motu, as I've just explained. And section 43 says, for the purpose of this, every information shall be disseminated widely and in such form and manner which is easily accessible to the public. So that means the information has to be provided and it has to be easily accessible to the public for disclosure, for their perusal. And all materials shall be disseminated in a cost-effective manner. It should not be like a brochure or an information handbook has been published, which is very high in cost, so that public cannot access this. Every person doesn't have the access to the website or the e-platform or various networks. A person wants information of the information handbook, and that or any other material, maybe prospectus of an admission for a course of study, or maybe any other document or leaflet on important matters relating to the public authority. It should be done in a very cost-effective manner and in the local language also, so that that information is being accessed by the people and they are being used properly for future course of action. And here the word disseminated means making known or communicated information to the public through notice boards, newspapers, public announcements, media broadcasts, and so on and so forth. Now, in this context, an important act also comes to the fore. It is the Public Records Act. This act regulates the management, administration, and preservation of public records, and it envisages a records officer as well. Why I'm mentioning about this is that when the particular Public Records Act is being followed by a public authority, so it automatically manages the records of the organization in a systematic manner. And when such records are kept in a systematic manner by the public authority, then the retrieval of that particular record or the information becomes easier and dissemination of information becomes easier. And so that is what the totality, that information has to reach the citizens in time when they seek such information, or it is disclosed suo motu. So these are a few of the obligations. It's just a jotting of the public authority vis-a-vis the RTA Act. So they have to appoint a CPIO or the SPIO or the APIO as well. Maintain catalog, index catalog records, enactment, the information handbook they have to put in the public domain, and then publishing all relevant facts while formulating important policies, then providing reasons for its administrative decisions, suo motu disclosures, information, then providing the annual reports, and awareness and education and training. We have discussed these provisions which are functional in terms of the functioning, the implementation of the Act, but there are other important provisions of this Act which deals with the actual management of this Act, which talks about section 12 and 15 of the Act deals with the constitution of the CIC and the SICs respectively. Similarly, section 13 and the section 16 deals with the term of office and conditions of service of the Chief Information Commissioner and Information Commissioners, both at the central and the states respectively. Section 14 and the 17 deals with the removal of the Chief Information Commissioner and Information Commissioners, both at the central and the states respectively. Then there is another important provision which is called section 24. It provides for intelligence and security organizations which are specified in the second schedule and are exempt from the provisions of this Act except matters pertaining to allegations of corruption and human rights violations. So this is a very important provisions, and the list of organizations are there which are in the second schedule to this act, and they are exempt from disclosure of regular information. Now, Section 25 of this Act deals with the monitoring and reporting of the CIC and the SICs, where the concerned information commissions are also, to do certain activities. And Section 26 deals with the preparation of the programs for the appropriate government to the extent of availability of financial and other resources. Section 27 deals with the power to make rules by appropriate governments under this law. And Section 28 deals with the power to make rules by competent authorities. And Section 29 deals with the laying of rules before the Parliament or the state legislature, which is a mandatory requirement. And Section 30 deals with the power to remove difficulties by the central government, but obviously that is within a period of 2 years from this enactment, and that particular time is already over. And Section 31, which is the last section, deals with the repeal of the Freedom of Information Act 2002. So in totality, these are the important provisions of this RTA Act, which we have tried to see one by one. And I've tried to give some inputs relating to its operational aspect and the functional aspect. And I'd like to also mention that the DOPT, Government of India, is the nodal ministry for administration of the RTA Act, and any interpretation, clarification regarding any provision can be addressed to them as well. And the website is obviously the firstmain.nic.in. One can see that. So this basically concludes the part of it, the jottings which I had done from various sources. There may be some abbreviations used here and there, and maybe some typographical issues, but one may overlook that. We tried to see this Right to Information Act in its totality, and we have seen how this act can be implemented smoothly without any problem, and it can be actually been used as an instrument to infuse transparency and accountability, leading to good governance. And when we talk about this particular aspect, I'd like to add a few issues that we discuss about this law in terms of various sections and how it is going to be dealt. And since the topic was right to information, so obviously it was I thought it was important that we discuss the sections. But a few important things also I'd like to share with you people. That when we talk about disclosure of information, now disclosure of information should also have some benchmark which can be developed by a public authority, and that can be done in a very transparent manner. Suppose a public authority, academic, let me focus on academic institutions here. Now, when an academic institution is going for an admission process, now if the information, all relevant information relating to the admission is already placed in the public domain through a very well drafted information booklet, which is priced at a very low price, as well as maybe it can be given free of cost depending upon the fiscal resources, and also put in the public domain through website, and proper information is already put of every possible situation that may arise while obtaining information for a particular course of study. So the students would be desirous of taking admission under the particular course of study will not put an RTI to seek information from that particular academic institution, or run to the information help desk, which is otherwise required obviously for various guidance. But such dissemination of information through a properly drafted information brochure is very important. The information brochure becomes the face of that particular admission process. And also, when the admission is underway, periodical dissemination of disclosable information which does not infringe upon the functioning, and giving a proper breakup of the seats which have been filled up, which are to be filled out, what are the cutoffs, what are the eligibility conditions, everything is put in the public domain. The number of RT applications on that count will reduce. Similarly, when we talk about an academic institution, we talk about teaching learning. Now, when information about the teaching learning, the syllabi, the courses of study, and every information about the schedule of the classes on a daily basis maybe and every information is put on the public domain in terms of the schedules and everything. The students will not be inconvenienced and run from here and there to obtain such information. And these kind of information, when they are put in the public domain right before the happening of the events, the functioning of the academic institution becomes easier. Similarly, when an institution is engaged in research activities, research and development, and obviously it deals with funds, it deals with various activities. So what happens, even the research outcomes which are disclosable and various research projects are being dealt, if such information which are disclosable is suo motu disclosed in the public domain, so such information will not be sought under RTA Act. And it is important to mention here that the financial estimates of an academic institution, or for that matter, any institution, should be available on the public domain, which will give a fair idea of the public money that is being spent by the institution, the purpose for which the public money is spent, and how the processes are being followed, and what quantum of the public money is spent, or if it is unspent, why it is unspent. So many information can be put in the public domain suo motu, so that the natural instinct of getting information in the public from the by the public from an institution becomes lesser and lesser through filing an RTA application. So this is important. Similarly, purchases and recruitment, these things also can be codified in a manner that maximum disclosure of information is put in the public domain, and appropriate clarifications are provided from time to time in the public domain, which are generally required by the students or by the prospective applicants for employment, so that they also do not put an RTA application under this act to obtain such information. It is otherwise available suo motu. And if the benchmarking is done, that information of particular nature will be automatically disclosed in the public domain, people will have confidence and faith in the functioning of the public authority or the academic institution, and that should actually help in dissemination of information as well as in smooth governance of the academic institution. So this is what I thought I'd be sharing with you people, and it's very kind of you that all of you have very patiently listened to me, and you have given importance to what I have said. So may I now request all of you, if you have any questions, you may ask.
Yes, sir. Thank you so much, sir, for such an exhaustive and a comprehensive lecture. Everybody is really happy to hear very interesting facts about RTI, which probably many of us would not have, taken a keen interest to study at our own individual pace. There are two questions, however, sir, which I would like to ask on behalf of the
Yeah.
participants. So the first question is by Miss Babita Sohag, and her question is, uh, which are the personal information which we can't reveal?
Uh, See, I put it in this way. See, what happens is that the RTI Act, if you go to Section 81J, if I can do so in this presentation itself, let me make an attempt to be there as fast as I can, so that I can read out that particular provision as well, uh, because that will actually also enlighten her on this particular aspect. See, what the legislature has done. Legislature has categorized the personal information. Now, there is no list which can be given for determining which information is personal information. See what happens, as I mentioned about the matter of G.R. Deshpande, where the annual property returns, income tax returns, and all such documents are being said that these are treated as personal information. The evaluated answer script of a student is personal information of that student can be disclosed to that person only. So in recruitment process also, there are various information relates to a particular student. Suppose a copy of an application form which has been submitted by the applicant with a lot of personal details. Suppose a copy of the application form for admission to a particular course of study with a lot of personal details a person has put, whether that can be provided. So these are the matters of actual deliberation. And when a particular request comes for information, then the concerned PI or the appellate authorities has to actually adjudicate on that request and see whether that information is personal or not. There is no exhaustive list available under any platform or anywhere that this group of information is treated as personal information. So this has to be decided on a case-to-case basis. Yes, ma'am.
Thank you, sir. Thank you so much for the answer. The next question is by Dr. Nabhanita Ghosh, and her question is, how long do we need to preserve answer scripts in anticipation of any RTI from examinees?
Okay. Now the thing is that every public authority shall have its own record retention schedule. And to the best of my knowledge and understanding, there is no hard and fast rule for that. Every public authority has to preserve the answer scripts, which will be voluminous documents if it is hard copy answer scripts and not the soft copies. And they have to be kept at a place. So there is obviously a requirement of space vis-a-vis the keeping the answer scripts for the safe custody. So obviously the public authority cannot keep such records until absolution. The public authority has to deliberate within its own parlance what is the space that is available for keeping such records and how long it can reasonably keep such records, for for the information seekers, who are the students who have sought who will be seeking information. And obviously that may be of 3 months, that may be of 6 months, or maybe a year. It depends upon the functional and operational aspects of that particular public authority, but at the same time, it should not be unreasonable. A public authority is saying that after 20 days or 15 days or 30 days of completion of the examination, the record will be destroyed. One has to see that a particular applicant, a student here, is given a reasonable opportunity after declaration of the result to see what the marks that person has got, whatever way it is, and then seek a copy of the evaluated answer script. The word is evaluated. So after evaluation, a certain period of time it has to be kept, and also there are obligations of reevaluation, rechecking, various others, addressing of student grievances. So I think every examination department of an academic institution should look at it from a functional perspective. But one thing is important. If an RTI application has been filed by a particular applicant and answer script at that point of time is available, so that particular answer script should not be destroyed under the garb of the record retention schedule, because the applicant has already made that request. So it is very important. The question of reasonability, it cannot be decided as a straight jacket question, because of the reason that there will be involvement of space, and maybe it's a huge constraint for a public authority to keep it. But obviously one has to be reasonable in terms of keeping not only evaluated answer scripts, for that matter any records has to be classified as permanent records and records for 2 years, 1 year, 6 months, 1 month, whatever. All records of a public authority has to be indexed and cataloged in this manner, so that dissemination as suo motu under section 4 or dissemination of information against a request under request from an applicant under section 6 onwards, whatever has been procedural aspects can be provided. So it is the reasonableness that has to be arrived at by the public authority, keeping in mind the student's interest as well as the operational aspect of its functioning. Right, ma'am?
Thank you so much, sir. So these were all the questions that were posed at you by the participants.
Okay.
So thank you so much for your time. We understand that you have been very busy, and still you took out very precious time from your busy schedule to
My
deliver
pleasure.
this lecture on RTI. We are so grateful to you, sir. Thank you so much for your time, sir. And with this, we come to the end of this lecture. And thank you so much, sir. And we at Ramanujan College will ensure that we have a long-lasting relationship with you in the future as well. Thank you so much for your time, sir. This is for the participants. We are through with this lecture on RTI. We meet again at 2:30 for another session on the university roster system. So please stay tuned for the link as well as other updates on the Telegram group. So thank you again for your time, and thank you so much, sir. Thank you so much.
Okay.
Thank you,
Yeah,
sir.
shall I make a
Yes, sir, you can exit now.